Και τώρα παρακαλώ τον Γενικό Γραμματέα του Διεθνούς Διαιτητικού Δικαστηρίου του ICC, τον κύριο Αλέξανδρο Φεσά, να εισηγηθεί το θέμα που προβλέπετε.
Κύριε Υπουργέ, κύριε Πρόεδρε, κύριε Καθηγητά, φίλες και φίλοι, κύριοι συνάδελφοι, καλή σας μέρα. Με μεγάλη συγκίνηση και με μεγάλη τιμή δέχτηκα την πρότασή σας, κύριε Καθηγητά, να μοιραστώ μαζί σας μερικές σκέψεις αναφορικά με ένα ζήτημα το οποίο έχει απασχολήσει και εξακολουθεί να απασχολεί την διεθνή διαιτητική πρακτική, τόσο στο πλαίσιο των διαιτησιών του Διεθνούς Δικαστηρίου Διαιτησίας, όσο και εκτός αυτού, όσο βέβαια και το ίδιο το Διεθνές Διαιτητικό Δικαστήριο. Θέλω να κάνω μια μικρή παρέκκληση και πολύ σύντομη, για να αναφερθώ στο γεγονός ότι πραγματικά αισθάνομαι συγκίνηση που είμαι εδώ μαζί σας σήμερα. Είναι νομίζω η πρώτη φορά που μιλώ σε ελληνικό κοινό εκτός της αιγίδας ή της ομπρέλας του Διεθνούς Εμπορικού Επιμελητηρίου και πραγματικά είμαι πάρα πολύ χαρούμενος γι' αυτό και σας ευχαριστώ και πάλι για την τιμή αυτή. Θα μου επιτρέψετε επίσης, ενώ δεν έχω ξεχάσει τα ελληνικά μου, θεωρώ, να απευθύνω σε εσάς τις σκέψεις μου στα αγγλικά προς όφελος του συνόλου του ακροατηρίου σήμερα. My subject is, as I was just saying, one that I hold dear to my heart, although one always risks of being misunderstood when one speaks of corruption as a matter that one holds dear to one's heart. But corruption in international arbitration is a subject matter in international arbitration, and its interrelation with public policy considerations is indeed topical. It's current. It's not just a fashionable topic or a hot topic. It is one that is quite focal, I believe, in the context of both commercial arbitration and investor-state dispute arbitration. I will be talking, therefore, in the next few minutes about this. I will not be addressing issues that are relative to it and which are sometimes confused with it, such as corruption by arbitrators or of arbitrators in international commercial and investor-state dispute resolution, or matters relating to fraud or corruption by arbitral institutions in arbitration. For those interested in this last matter, there have been some interesting developments that surfaced in the legal press a few weeks ago. Now, why are we talking about corruption, ladies and gentlemen? Well, first of all, corruption, and here I use one of the definitions that has been adopted in multilateral international instruments, can be seen as an act whereby something of value, including money, is transferred to a public official or a person who works for the private sector in order that the recipient engage or refrain from acting in something that is improper or in breach of his or her duties. It encompasses a variety of different wrongful acts, including bribery, which is sometimes called stricto sensu corruption, trading in influence, abuse of functions, and money laundering, to name but a few. Now, corruption presents significant risks for investors conducting business in nearly every corner of the world. Transparency International, which is a reputable and non-governmental organization, recently found out that over 2/3 of the 176 countries and territories it surveyed scored below 50 on a scale from 0, highly corrupt, to 100, very clean. The global average comes in at 43, indicating the endemic presence of corruption worldwide. Furthermore, corruption costs more than 2.6 trillion US dollars. It's 5%, that is 5% of the annual global GDP, with over 1 trillion US dollars in bribes annually. A few years ago, in 2003, the then Secretary General of the United Nations, Kofi Annan, described corruption as, quote, an insidious plague that undermines democracy and the rule of law, leads to violations of human rights, distorts markets, erodes the quality of life, and allows organized crime, terrorism, and other threats to human security to flourish. Now, let's focus a little bit more strictly on arbitration and the emergence of, or the treatment of corruption allegations in the context of arbitration. For the longest time, ladies and gentlemen, corruption was considered to be a matter surveyed and assessed and decided upon explicitly and concretely under the purview of domestic law considerations. Now, there's a reason for that, but I think that that reason has gradually receded, and it has been, I think, primarily due to the demands of cross-border trade, transnational trade, and the prevalence of illicit practices internationally that have brought or shifted the debate on corruption from the purely domestic field to a more international, if not now even transnational field of activity. It is for this reason also that we have multilateral conventions in place tackling matters of corruption, such as the UN Convention Against Corruption, which I think is strong at 170 parties strong currently. You also have the OECD Convention on combating bribery of foreign public officials in international business transaction, and of course the Convention on the fight against corruption involving officials of the EU communities. Now, all those corruption allegations, as I mentioned a moment earlier, are now becoming increasingly common in international arbitration. There are three main reasons, I believe, for that. First of all, we see whenever there is a change of regime in many states or a succession of political parties in the context of any given state, we see a certain, sometimes a certain appetite for purge of past practices whenever such governmental change takes place. One example that we're all familiar with is the results of the Arab Spring. More recently, we've seen it to a certain extent or to a large extent in Brazil, to a certain extent in Turkey, and in a number of sub-Saharan republics. The second reason is the development of and the existence now of a comprehensive international regulatory regime on the basis of the conventions that I mentioned earlier. And the third, which is also quite notable, is the progressive growth in the use of arbitration in the context of investment treaty operation. An investment is protected to the extent that it's legal, or an investment exists to the extent that it's legal under bilateral arrangements. If it is corrupt, it is illegal, and therefore it may not be protected. Now, in most instances, all allegations of corruption, all the allegations of corruption are made by a respondent in the context of a defense or as a means of defense against a claimant whom it accuses of having engaged in corrupt practices. And in that sense, of course, corruption allegations are often parallelized or described as a shield. However, allegations of corruption may also be made by claimant, and in that instance, we describe them as a sword rather than a shield. For instance, to support a claim that the underlying contract between the parties is null and void on account of corruption. Corruption allegations may also be made in the context of the procedure itself, with procedural requests aimed at engaging the powers of either the tribunal or even the arbitral institution when one exists. So when a claim of bribery or corruption is raised in the context of an arbitral process, the arbitrators primarily must decide how to go about it. Now, the tribunal will be confronted with a number of matters, such as jurisdiction, arbitrability, the burden and/or the standard of proof, as well as its own power to investigate these matters sua sponte. And those are some of the things that I will be discussing with you today. The reason that I said earlier that I find this topic quite mesmerizing and is one that I hold close to my heart is because most of the available information with regard to approaches by arbitrators in matters of corruption are the direct result of ICC arbitration, which has consistently provided a concrete body of awards and decisions which serve as reference in our understanding of how corruption allegations should be or could be addressed, and in the formulation, the progressive formulation of best practices and guidelines as to how one should go about it. Obviously, ICC arbitration is not the only forum where corruption allegations are being addressed, but again, I would like to stress the fact that if one looks at published articles, doctrinal approaches, and even case law, one will probably be able to confirm what I've just said. So we have gone a long way, ladies and gentlemen, and then for the longest time, matters of corruption were seen or were addressed by tribunals as a jurisdictional issue. Corruption is not something that arbitrators should actually dip their feet in. There was a big change almost some 60 years ago, and Professor Calabros alluded to the arbitrator and the awards, which was rendered in ICC case 1110 by Judge Lagergren in 1963. Now, in that case, an agent was commissioned by an English company, to exert influence over members of the Argentine government when bidding for a public works contract, a public concession contract. Now, after hearing the witnesses and reviewing the evidence, but before making any pronouncement on the applicable law, on the substance, Judge Lagergren, who was acting as a sole arbitrator, decided to inquire ex officio into the validity of the contract, which had been called into question by the parties. And he relied on Article 5 2b of the New York Convention, which recognizes the power of state courts to refuse recognition or enforcement of awards which are deemed to be contrary to public policy. And in doing so, he considered that from the outset of an arbitration, arbitrators, and this is 1963, arbitrators should be vested with a similar power to refuse a case that risks infringing public policy. His conclusion was that by allying themselves with corruption, parties had forfeited any right to ask for assistance in the machinery of justice, and he declined jurisdiction. There has been, or there was, if you like, a to and fro between different arbitral tribunals at the time with regard to this jurisdictional threshold issue. Although nowadays, I should note, arbitral tribunals tend to address issues of corruptions in terms of admissibility of claims, the legality of the contract, or indeed transnational public policy. And contracts tainted by corruption may be found ultimately invalid on the basis of national laws, international conventions, and, again, transnational public policy. Now, how an arbitral tribunal evaluates the evidence that is brought before it is crucial to the outcome of this appreciation of corruption allegations. And obviously, corruption allegations and their assessment are heavily dependent on factual determinations, and therefore the matter of the treatment of evidence is extremely crucial in this debate. Now, most institutional rules, and I think this is something that is sometimes forgotten, but most institutional rules, including the ICC rules of arbitration, are silent on the burden of proof and on the standards of proof that should be applied by arbitrators. they do provide guidance, and again, that is sometimes also easily forgotten. If one looks, for instance, at Article 25.1 of the ICC rules, one will see that an arbitral tribunal must establish the facts of the case by all appropriate means. And this is not just guidance. This is not, it's a rule, which means that arbitrators actually have discretion to do that. And I will come to that in just a minute. Now, burden of proof, since we're speaking of evidence. Some ICC tribunals have been seen to shift the burden of proof once a prima facie case is made by the party alleging corruption. So if there's a prima facie finding that corruption may exist, then the burden of proof shifts to the party that is allegedly the perpetrator of the corrupt activity. Now, such an approach has been lauded by arbitrators and certain commentators as the appropriate means of allowing the accused party to meet the requirements of law and good faith. It has also been encouraged by the fact that it is usually easier for the innocent party, if an innocent party indeed exists, to produce the necessary countervailing evidence in support of its innocence. A little bit more tricky is the issue of standard of proof. What is the standard that an arbitral tribunal should use to evaluate the evidence that has been adduced before it? There is no uniform reply here, and this is a matter that has been very hotly debated. And indeed, arbitrators acting under the ICC rules have taken those varying approaches. It is notoriously difficult to fully prove that an act of corruption has taken place. And it is not always clear on what basis one should assess all the public policy considerations that are raised by an alleged act of corruption. So there are those who speak in favor of a very, very strict standard being applied. There are those who speak on a more relaxed burden of proof, and so on and so forth. My personal view, and I am not wearing an institutional hat right now, my personal view is that this, in a way, is a misleading discussion. Again, arbitrators under most institutional settings, but also in purely ad hoc settings that are administered under the United Nations, or UNCITRAL rather, rules on arbitration, do enjoy discretion to evaluate evidence by all appropriate means, subject, of course, to the parties reaching different agreement. And therefore, the issue of standard is something that is really not the best way of addressing this. And this is where I think we have seen very significant progress being made, both in the context of commercial arbitration and investor-state arbitration, and ultimately in state court review of these matters. And that important progress is that the issue can be, and very often should be, approached on the basis of whether a party may rely convincingly on a number of indicators of corruption, and whether those indicators are sufficiently pointing towards the actual existence of corruption. Now, in English procedural law, this may be called circumstantial evidence. In international arbitration, and even outside of it, it's called red flags, indicators that may point towards, concretely or not, towards the existence of corrupt activity. The seminal example, or the textbook example, are intermediary or consultancy agreements, where the tricky part there, of course, is that the intermediary gets money, is remunerated for procuring a contract, and not for providing the service that the contract, the intermediary agreement itself provides. So it is more a remuneration on the basis of the result than the means that one employs in achieving that result. Let's consider, and this is an ICC case, let's consider a situation where the intermediary is required to procure the supply of a number of contracts in the context of state concession agreements. In order to ascertain whether those state contracts, the conclusion of those state contracts may have been procured via corrupt practices, the arbitral tribunal can ascertain those indicators, those red flags, which may include any of the following. Whether the description of the services in the consultancy or intermediary agreement are defined or not defined in that contract, and are they clear or are they unclear? Whether there exists a time frame within which that concession contract should be achieved. In some cases, the contracts have been obtained just days after the intermediary agreement had been reached, which in and of itself is a little bit suspicious. More broadly, the shorter the time frame between the conclusion of the intermediary arrangement and the supply of the contract itself, the stronger the indicator may be on the existence of some sort of undue influence. Now, the value of the commission agreed upon to be paid to the intermediary for the successful procurement of its services. Now, there are cases where that remuneration is extraordinarily high or completely disanalogous to the subject matter of the intermediary arrangement itself. The manner in which the intermediate is being remunerated, the more complex, the more suspicious. And finally, the existence of proof that that intermediary agreement was in fact performed. Is there performance under the contract which seems to have resulted in awarding a public supply contract? This is a summary of a number of ICC awards that we've seen from the 1990s to today in commercial cases. There exist similar examples in investor-state disputes. There are two notable examples, incidentally both involving the Republic of Uzbekistan in the 2010s, 2013 and 2016. I won't go into those, but I'm happy to describe them later on during the break. The same approach seems to have been adopted, at least to a certain extent, by case law, which is, again, a very welcoming development. And here I will limit myself to French case law, given that my headquarters are in Paris. There's a very interesting decision by the Paris Court of Appeal rendered in 2017 in the context of the arbitration between Belokon and the Republic of Kyrgyzstan. Now there, Paris Court of Appeal set aside an award, an ad hoc award, that would have allowed claimant to profit from money laundering activities during a tender process for a supply contract tendered by the Republic of Kyrgyzstan. This is one of a couple of decisions by the French Court of Appeal. What they have contributed to this discussion is probably something that I consider to be really the solidification and the full fully embedment or embedment of the notion of how red flags should work, and therefore the clear emergence of a more transnational rule, which has now been elaborated both by tribunals and international instruments and state courts, and that it's not sufficient to have red flags or indicators of illicit, corrupt activity. But what is required, in addition to that, is that those indicators of impropriety be serious, precise, and converging. And this test has been applied by the Paris Court of Appeal and other courts since, with some consistency, and in some cases, of course, affirms the existence of illicit activity or does not affirm it, and conversely, of course, may lead to the setting aside of awards or not. There are many other issues that are equally captivating and interesting. For instance, what powers do arbitrators have in investigating corrupt activities? Especially when the parties themselves may not have raised those matters in the context of the arbitration. The point is often made that if an arbitral tribunal raises the issue of corruption sua sponte, it will proceed to make a determination on the existence of corrupt activity that and draw consequences which may go beyond the party's praise for relief, and therefore proceed with making an ultra petita determination, which may then in turn lead to the setting aside of the award or its non-enforcement. Again, my personal opinion, and I emphasize that this is my personal opinion, is that this point seems to disregard that a finding of ultra petita may lead to the setting aside of an award or its non-enforcement to the extent that the arbitral tribunal grants more than what the parties have actually requested. But this is not the situation or the scenario which we are discussing today. In fact, the arbitrators in deciding matters of corruption sua sponte are actually doing something different. They are relying on arguments which may not have been brought in the arbitration by the parties themselves, but they're not awarding something more than what the parties requested. So this is not really a question of an ultra petita assessment or not, but more a matter of the tribunal becoming a more active individual component within the global fight of corruption. And in doing so, of course, it must also ensure that due process and the right of the parties to be heard is maintained. And therefore, in deciding sua sponte, obviously that is a matter that needs to come before the parties for full briefing. And this, I believe, has ultimately led to the rather firm establishment of a clear transnational public policy rule, and that is that arbitrators are empowered and indeed may even have a duty to investigate and adjudicate corruption issues. There are other very interesting matters that I would also like to share with you, but I won't, in order not to spoil your appetite for further debate later on with my colleagues. Matters of restitution. Can you seek restitution of the consideration that is the product of illicit activity? The traditional view is that you can't, but there are now arbitral tribunals who say that that might actually lead to a very unfair result, especially when the interests of the parties are not the same. Can you take into consideration mandatory rules, lois de police, as the French call them, that are not part of the lex contractus, which would, under certain circumstances, lead to a finding of invalidity because of a corrupt activity? If a state says that the procurement, that you cannot have consultancy agreements in the context of state procurement for defense purposes, yet the contract in question is not regulated by the laws of that state, but by another state. The lex contractus is completely different. Does an arbitral tribunal have to give effect to that mandatory law, which is outside the lex contractus and not even part of the lex arbitri? Again, the Paris Court of Appeal has consistently said that that should not be the case, that those lois de police, again, are not applicable in that matter, and they do not amount to a breach of transnational or international public policy. I would like to end, ladies and gentlemen, with a more positive note, and one that looks towards the future. Corruption is an issue that has kept many an arbitration practitioner busy. It's also attracted academic attention and will continue to do so. Earlier this year, the University of Basel, the Competence Center Arbitration and Crime at the University of Basel, published a toolkit for arbitrators on corruption and money laundering in international arbitration. That is available online. And it complements a number of other similar initiatives that both the International Chamber of Commerce and many other associations and institutions have offered and may be used by practitioners in arbitration. Closer to home, the ICC court the attention of the ICC court and of the Secretariat of the RCC court may be alerted by a combination of factors in any given dispute, signaling that the case should be given careful consideration. For instance, parties not being represented by outside counsel. Those are, again, if you like, red flags. In and of themselves, they don't mean anything, but in the context of any specific dispute, and depending on how one combines them, they may lead to a certain red flag being raised. So the parties are not represented by outside counsel. The dispute is to be heard by a sole arbitrator chosen by the parties, or even you may have an arbitration agreement that identifies eponymously who that sole arbitrator will be. The parties accept the jurisdiction of the arbitral tribunal expressly. The parties fully agree on the list of issues that need to be determined, and that list is, unsurprisingly, extremely short. The parties acknowledge that they themselves have failed to perform the contract, and they accept that there's liability. The parties, after all of that, also request an award by consent. And sometimes even the scope of the arbitration agreement implicitly or explicitly even excludes the question of examining the validity of the underlying contract. And there have been cases that have been brought before the ICC court, draft awards, for instance, for scrutiny, which require the attention of the court on these and many other matters. And I remember a case not too long ago where performance of the contract had not been proven. No party pled it. No party raised any concerns about that, and the arbitral tribunal itself did not seem to be too much bothered with it. Well, the ICC court was, and that draft award was not approved when it first came in. I would like to conclude, and this is my final thought, with a further look into the future and the work that the ICC Commission on Arbitration and ADR is doing in the context of corruption. So the Commission, a few months ago, established a task force that will be looking into issues of corruption in international arbitration. The task force, and I have to say that Greek petitioners, members of ICC Hellas, are members of that task force, and it's a very welcome move. The mission or the scope of the work of this mandate is quite broad. It will involve determining the definitions to be used and in understanding what corruption is, public-private sector corruption, what forms of illegality may be taken into account, the extent to which its work should also include, aside commercial arbitration, investment arbitration, proceed with making research, analysis, and dissemination of information by looking into ICC practice, other institutional practice, and then domestic law practices as well. And this is where the viewpoint of practitioners in various jurisdictions become extremely pertinent, and obviously identify red flags, to the, indicators or badges to the extent that that is necessary. And finally, collaborate even on a broader spectrum and outside the confines of ICC arbitration with other sister organizations such as the IBA, the International Bar Association, and the OECD, which have equally launched their own task forces on corruption-related matters. We started, and we will end, with Judge Lagergren and his award from the 1960s. Judge Lagergren mentioned at some point in that award that bribery and corruption are contrary to good morals and to international public policy common to a community of nations. It is precisely 58 odd years after the publication of that awards that this discussion on the interplay between public policy considerations and corruption allegations in international arbitration is still so pertinent. Thank you all very much.